The court that never said yes. For more than a century, the Ninth Circuit Court of Appeals was known as the graveyard of the Second Amendment. Every challenge to a California gun law seemed doomed before it even began. But on August 14, 2025, history flipped. The same court that had rejected gun rights claims for 134 years issued a final mandate, not a suggestion or a temporary win, but a legally binding order striking down one of California's strictest firearm laws. We break down what really happened, why this ruling matters nationwide, and how it could permanently change the balance between state power and the Constitution. If you value your rights and want fact-driven updates without the spin, hit subscribe because this one is a turning point. Chapter 1. A shocking first in 134 years. Since its creation in 1891, the Ninth Circuit has almost always sided with government regulation over individual liberty. Across decades of cases, background check challenges, magazine bans, and waiting period lawsuits, the result was the same every time. Gun owners lost. That unbroken streak ended with Nwin versus Bonta. For the first time in its history, the Ninth Circuit did not just issue a favorable opinion, it released a mandate, the court's final word, making the decision binding across its entire jurisdiction. The case overturned California's one-gun-per-month purchase rule. It reaffirmed that constitutional rights cannot be rationed by time or quantity. It marked the first-ever Second Amendment mandate in the Ninth Circuit's history. For gun rights advocates, it was more than a win. It was proof that even the nation's most restrictive court can no longer ignore Bruin's constitutional standard. Chapter 2. The case of Nwin versus Bonta. At the center of the fight stood one question: can a state ration a constitutional right? California's Penal Code section 27,535 limited residents to purchasing one handgun every 30 days, even after passing all background checks. Plaintiffs argued that this rationing rule turned the Second Amendment into a privilege instead of a right. They cited New York State Rifle and Pistol Association versus Bruin, decided in 2022, which requires modern gun laws to align with America's historical tradition. No such tradition exists of limiting how often law-abiding citizens may acquire firearms. The state failed to show any founding-era precedent for rationing access to arms. In June 2025, a three-judge Ninth Circuit panel agreed, striking down the law as unconstitutional. Then came the shocker. Instead of reversing the decision, the court issued the mandate on August 14th, closing the case for good. Chapter 3. Why this has never happened before. To grasp how monumental this is, consider the Ninth Circuit's pattern. Each time a lower court favored gun owners, the full court, through an en banc rehearing, would erase it. In Duncan versus Bonta, a magazine capacity ban was struck down, only to be reinstated by an en banc reversal. In Miller versus Bonta, an assault weapon ban was ruled unconstitutional, then immediately stayed. Similar outcomes followed in ammunition and open carry cases. That is why the Nwin mandate stunned both sides. For the first time, a Second Amendment ruling survived inside the Ninth Circuit. It was not stayed, reversed, or sent back. It stood firm, signaling a profound shift in judicial philosophy. Chapter 4. California's Relentless Counterpunch. AB 1078. California did not wait long to respond. Within weeks, lawmakers introduced Assembly Bill 1078, proposing a so-called 3 guns per month limit. On paper, it looked like a compromise. In reality, it was defiance. The bill's sponsors claimed it balanced public safety with the constitutional rights. Legal experts quickly noted that the same logic the court rejected in Nwin applies here. Rights cannot be rationed, whether once, twice, or 3 times per month. As of October 2025, AB 1078 had cleared the Assembly and was under review in the state Senate. Gun rights groups, including the California Rifle and Pistol Association, vowed immediate litigation if it passes. The message from Sacramento is clear: they may lose battles, but they will not stop testing the limits of the Constitution. Chapter 5. You can't ration rights, what the court actually said. The Ninth Circuit's language left no room for doubt. The judges wrote that constitutional rights are not privileges to be dispensed by the state. The opinion compared gun purchase limits to restricting worship to once a month or limiting publication frequency for journalists. Such rationing, they said, has no basis in the nation's historical tradition and no place in American law. The ruling clarified that the Second Amendment stands on equal footing with every other enumerated right. In short, the state cannot decide how often citizens exercise freedom. The mandate makes this reasoning binding precedent throughout the Ninth Circuit, setting the stage for challenges to any future attempt to ration rights. Chapter 6. The Ripple Effect Beyond California. This mandate does not just change the law in California, it sends shockwaves across the entire western United States. The Ninth Circuit's jurisdiction covers 9 states, including Alaska, Arizona, Hawaii, Idaho, Montana, Nevada, Oregon, and Washington. Each of these states must now recognize the same constitutional boundary. The court made it clear that rationing rights, whether it is 1 gun per month or 3, violates the Second Amendment. Lawmakers in other states will have to reconsider any similar restrictions. Future courts will be forced to ask a simple question. If the Ninth Circuit calls it unconstitutional, how can any other state justify it? While the ruling does not instantly erase every restrictive law, it establishes a clear precedent. It is a legal marker that cannot be ignored, signaling that time-based or frequency-based firearm laws have no foundation under American tradition. Chapter 7. California's Counterattack. If there is one thing California lawmakers have proven, it is that they never surrender easily. Even as this mandate was finalized, Sacramento was already preparing its counterpunch with Assembly Bill 1078. Think about that. The court just ruled that rationing is unconstitutional, and the state's response was simply to ration differently. The new proposal allows 3 gun purchases every 30 days. Supporters are calling it a safety measure to limit trafficking. Opponents argue it is a direct attempt to sidestep the mandate. This is not just resistance. It is an open defiance of constitutional limits. And if California succeeds in redefining the boundaries, other states will follow the same path. This battle will determine whether the Nwin versus Bonta mandate stands as a permanent victory or becomes the start of a new round of legal warfare. Chapter 8. Why the Mandate is Bulletproof. Here is what makes this moment truly historic. A mandate is not a temporary opinion or a soft ruling. It is the court's final, enforceable order. California cannot appeal it. The Ninth Circuit cannot withdraw it. Even the Supreme Court has no obligation to step in, because there is no controversy left to review. The mandate locks the decision as binding law. It prevents further delay, reversal, or modification. It forces compliance within all states under the Ninth Circuit's authority. For gun owners who have spent decades watching victories disappear overnight, this is the first solid legal ground in generations. The mandate issued in the case of Nwin versus Bonta is not just another temporary panel win waiting to vanish. It is a lasting precedent that stands on its own, marking the beginning of a new legal era for the Second Amendment. Chapter 9. The Political Earthquake. The political impact of this decision cannot be overstated. For decades, anti-gun advocates relied on the Ninth Circuit as their firewall. It was the court they could always count on to uphold restrictions. That firewall has now cracked wide open. Attorneys across the country will cite Nwin versus Bonta in every rationing-related case. State legislators in places like Nevada and Arizona will now face pressure to align their laws with this ruling. National organizations are already using this case to challenge new proposals in other circuits. Politically, this changes the national conversation. Lawmakers who once leaned on the Ninth Circuit's history of deference to gun control now face the opposite reality. The most restrictive circuit in America just delivered one of the strongest victories for gun rights in modern history. Chapter 10. The next battles ahead. Victories like this are rare, but they are never the end of the story. The fight now shifts from winning courtrooms to defending this precedent in every possible way. California will continue pushing new forms of restriction, dressed up as safety measures or registration laws. Expect to see new bills disguised as minor adjustments to purchasing systems. Watch for data collection schemes targeting firearm transactions, and stay alert for digital surveillance efforts under the name of safety tracking. Each of these measures will test whether the Nwin mandate truly holds its ground, or if states can find loopholes to weaken it. This ruling is not just about guns. It is about whether states can continue to erode constitutional freedoms under the label of public safety. The message to gun owners is clear. Stay vigilant, stay informed, and never assume a win means the fight is over. A century in the making. For 134 years, the Ninth Circuit has never sided with the Second Amendment. Gun owners lost hope. Attorneys stopped filing challenges. The court was considered a dead end for gun rights. But in 2025, that changed forever. The mandate in Nwin versus Bonta will be remembered as the moment the Ninth Circuit cracked open the door it had kept shut for generations. A court once known as the graveyard of the Second Amendment has now become the birthplace of its revival. History is not written by a single case, but this one just rewrote the narrative for gun rights in America. So here's the question every gun owner must answer. Will you stand to defend this victory, or will you allow states like California to bury it beneath new layers of restriction? The courts have done their part. Now it is up to the people. Share this video to help others understand what this mandate means for the future of the Second Amendment. Leave a comment and tell us whether you think this signals a true turning point or just another temporary win. Stay informed, stay responsible, and as always, stay free.